when you have kids, when you get divorced, when your kids get married, when your parents die. It's a great time to review all that stuff. I mean, there are a lot of different these life events that certainly could change, who's going to be listed in that will, what assets are in the will, what else am I missing, right? Those are really great opportunities to kind of review that stuff, and something that can be missed oftentimes.
Welcome to the Path to Passive podcast, where we talk about building wealth and empowering lifestyle through commercial real estate investing for tech professionals. I always wish that other tech professionals reaching financial freedom had documented their journey along the way, so I'm doing it for the rest of us. Join us as we explore stories, many failures, and lessons learned along the way. I hope you enjoy and subscribe. Dude, can you believe that we are on episode 3, the third of this series? Yeah,
I've been impressed. I mean, we've gone deep into some of these topics, though.
Yeah, this is really awesome information. Glad to have you back here for another episode. This is 3 out of 3. And, we went into a lot of information already on those first 2 episodes. Number, 1 is just setting the foundation of all the things around what exactly is an SDIRA, what are the benefits, et cetera, et cetera. And so, for everyone listening, make sure if you haven't already, go back and check out episodes 1 and 2 so you can get a solid foundation. There are some gotchas along the way that Collin has made sure that we have covered. And in episode 2, this one builds on top of it. It's also a critical episode to listen to because there we talk about, some of the things that we don't hear as much about, such as some of the other accounts that you can open up as well, that you can also partner, those different accounts and some strategies around that so that you can build this really around, I would almost say your own little ecosystem around, your family as well, considering things like, ESAs and, HSAs for different purposes. So today we've got something that's really cool that, is we think about retirement is one thing, but we also think about what it's like for, just to be frank about it, right? And upfront about it is that we have sometimes for ourselves, we are going to get older and we are going to pass down things like our generational wealth. And sometimes that means that we might, be giving our account to someone else for them to inherit it. And sometimes it means that we'll be inheriting accounts as well. So we're going to be covering those major things in this episode. So let's kick this off, Collin. Let's talk about this first topic, which is about inheriting accounts, and just remind everyone what your background is, what you do here, and the expertise that you bring to the listeners, if you would.
Absolutely, Stephen. And again, like the last time, it's a pleasure to be back. the third installment. We're nearing the end of topics I think that I can cover. No, I'm just kidding. But I'm one of the IRA specialists here with Quest. I've been with the company now for about 3 years and worked my background in holistic financial planning before that. So nice. I'm not sure if I mentioned that to you before or not.
No, I don't think you have. First time I just heard that. So.
Tax, estate, risk management, planning, portfolio management, investment. I mean, all of that was kind of my background before. The alternative investment side was really what I pursued, more heavily. So
cool. Yeah, that makes a lot of sense where you're able to talk on a big variety of things there. So super cool. Like I said, pleasure to have you here. And this is the 3 of 3. So we're going to be talking about, let's kick us off into inheriting accounts. So, let's set the situation, right? The situation here is exactly like it sounds like. We have someone who has an account, we'll call our parents an example instead of a good example. And they have passed it down to, you, the listener, getting an account. So what is, first off, it's always from someone, like what are scenarios, Collin, of who will be passing an account down? Is it always like a parent-child relationship? Does it not matter who's able to pass an account down?
Yeah, I mean, anybody who has an IRA, guess, is really what it comes down to. I think what's so interesting about these inherited accounts is it's not something people, prefer to think about, right?
Mm-hmm.
They're not, that whether it be themselves or maybe their parent or their aunt or uncle, whatever the case may be. You're not there sitting thinking about what's going to happen to this IRA after this individual, this very important person in my life passes away. So
Right.
It's not something that's probably talked about enough, but is definitely an important conversation. And yeah, I mean, all IRA accounts and different, depending on the custodian or the institution, may handle this differently. But the way that we do it is we make sure that all of our IRAs are set up with at least a primary beneficiary when the account is set up. So that way there is somebody, otherwise you'd have to, go through probate, do all that. We don't want things to pass to the estate and go through that whole process because, as you may know, that
could be messy.
Sometimes years, right?
Yeah.
So we always make sure that there's a beneficiary listed and they can name whoever or whatever. Some people will name their trust, some people will name their kids, some people will name their spouse. I would say spouse or kids are really the most common we see calling us and saying, hey, I need to set up an inherited IRA. My mom or my wife or my husband or whoever just passed away.
Got it. Great. So we'll get more into talking about, probate and just what that is in the future for those that aren't familiar with what it is. But needless to say, as Collin was just pointing out, it's a long and tedious process. And of course, the government gets involved with all these things. So let's just say that in terms of inheritance, it's one party names a beneficiary or who benefits and will be receiving the IRA, right? So, person one, entity one passes down to entity two. Could be a person, whoever is named, right? So cool. So talk to me about that. It's having a beneficiary named, obviously good hygiene as well, just to make sure that all the paperwork is in place. I mean, I've heard of horror stories where the name was still in like the ex-wife's name, or like it was in someone else that died or something else like that. So yeah. Important for
that's definitely a very, very, very important point. And I will say some of that stuff is going to vary state to state just based on what the estate laws are. The way that it is in Texas is the IRA trumps a will. So if you changed your will and didn't change the beneficiary with your custodian that holds your IRA, whatever the will says regarding the IRA is essentially null and void. So if you still have the ex-wife or the ex-spouse listed, it's unfortunate, right? But there's not much we can do.
Got it. So that would definitely be a got you for, like you said, state to state wherever people are listening. Make sure that they're asking the questions on, right?
Definitely. And yeah, if there's, people that are estate planning or they're talking to an estate attorney, that's definitely something that needs to be a part of the big picture, and it needs to be included in making sure that that's prepared for. So even if, the will may not necessarily be able to override whatever the IRA beneficiaries are, then they'll want to make sure that they take care of that whenever that time is.
Right. The important part, we'll circle back to on that too around the estate planning part. But let's get into the meat of it. So we know there's two entities. One is basically giving it to another because we'll just call it, people are fallible creatures and it's not pretty, but let's say someone has passed away. And so what does the conversation look like? Let's say, what is a conversation that you've had with someone else where this has just happened, this situation happened, and someone has passed away and they're looking to get this IRA and receive it. What does that look like?
Yeah. So, I mean, the first thing that I'm always going to say to somebody is, I'm sorry to hear about that. I'm sorry for your loss, right? That's a really important point that we make in trying to take care of our people too, because they're going through a very hard time, right? Understandably, especially 100%. If this is something that's just recently happened. But really where we're trying to shift the conversation in terms of IRAs is options, right? And what options, what capabilities they have within these accounts. Some people, their parents may have been real estate investors their entire lives. They might have invested in 50 different multifamily syndications, right? But that's just not their forte. Maybe the kids are more into cryptocurrency now. That's a big thing, or just investing in mutual funds, right? Whatever that is.
Yeah.
So in terms of the investment options, right, there's absolutely no need for the accounts to stay here. Well, we're happy to work with them, happy to move it wherever they want, whatever makes that, the beneficiary comfortable.
Yeah.
Right. In terms of legal options, this can kind of depend, like, how long they would be able to keep the IRA and different things of that nature. Would depend on a variety of different things. I wouldn't say we need to go down each, individual rabbit hole, but essentially, whenever Congress passed Secure Act, it changed a lot of the beneficiary rules. So pre 2020, so we're talking December 31st, 2019 and behind.
Got it.
Most individuals could take an IRA, an inherited IRA, say from their parent, and be able to take lifetime withdrawals out of that. So every year you would have, basically the IRS has a table. They say, this is when you're expected to pass away. So based on that lifetime factor, here's how much you can take out of the IRA each year, or really how much you have to take out of the IRA each year so that it is depleted.
Right.
So nowadays, at post January 1st, 2020, that option is no longer available. Only available for spouses in certain scenarios. But really, a spousal beneficiary can actually take on their deceased spouse's IRA as if it were their own.
So let's unwind that a little bit, because I was starting to get a little bit confused.
Yeah.
So you're saying that these are the I forgot what the acronym is, but it's the required distributions or something like that.
Required minimum distributions, or RMD.
Yeah. RMDs, right? So let's say what you're saying is, let's say that the parent, as an example, is 80 years old or whatever the age is, and they have to start taking required minimum distributions, RMDs.
Yep.
If that person becomes deceased, then we'll call it the child, just as in this case. What are the options for them? Can they also start taking distributions?
Again, that really depends on a few different things. If the child is not of the age of majority, they're still a minor, they can generally pause those distributions until they turn 18 or 21, depending on the age of majority in your state.
Yeah.
And sometimes, like, normally for children, yes, they would have to continue the RMDs unless they're a minor.
Unless they're a minor.
Unless they're a minor.
Mm-hmm. Okay, got it. So they have pretty much access to the cash distributions or other, or still the ability to go invest that as well.
Yeah, absolutely. And so if RMDs have started or they need to start, right, you're going to have to factor that into what you can invest, making sure that there's enough cash available for those distributions. But the rest of the money, and so I didn't even touch on this, but generally the rule is now, especially for a child, right, somebody who's not a spouse, you have 10 years to maintain that IRA until you have to take everything out.
Okay.
So you would have really a 10-year period to continue to reinvest that money as you see fit. For the most part, the IRS says that you don't have to take an RMD every single year. Just at the end of that 10-year period, everything has to be out.
Got it. So, for example, parent has the IRA. They're not at a place to have to take required minimum distributions. Something happens, they become deceased. Then the child gets it. We'll just keep it that example because it's probably more common use case in
more applicable.
And so let's say the child is, I don't know, we'll call him 30 years old as an example. All right. When would they have to start taking RMDs for that IRA?
Um, really, in that scenario, assuming that they're wanting to create longevity, keep money in the IRA as long as possible,
Yep.
it would all have to be gone within 10 years.
Okay, got it. So the 10-year rule still is that consideration then?
Mm-hmm. Yeah.
Okay.
Yeah, I would say just as a general rule of thumb, for just about any beneficiary, you're going to have 3 different options.
Okay.
Take everything out of the account. So just take a full distribution, lump sum.
Got it.
Roll it over into an inherited IRA and continue with that for 10 years until you have to take everything out. Or some, this happens very rarely, but you could choose to disclaim it, right? If you don't want the inheritance, or you're trying to maybe hope that your child would get it after you or something like that, right? You could disclaim it. The only exception to that is for spouses. Like I mentioned, if you are a spousal beneficiary, you would have those 3 options along with a fourth, which is actually taking on the IRA as your own. So basically, that kind of does away with the 10-year rule, and now you can have that IRA for the rest of your lifetime.
Got it. But assuming that spouse has a beneficiary, the IRA still has a beneficiary after the spouse, then the 10-year thing would probably still apply too, right?
Yes.
Got it. I know that's like another hop, but
yeah,
following
the and yeah, beneficiary inherited rules can get pretty in the weeds, because a lot of times, like you were already talking about, right, it's going to depend on the age of the deceased individual. Had they not started RMDs? What is their relationship to the beneficiary? How old is the beneficiary? So there's a lot of different factors we go through in determining what options are available.
All right. So instead of exploring all of those, because it sounds like it can get pretty complicated, and we have enough things to remember during the day as is. What is the process? So what's the process? So say I, knock on wood, say someone happens for me, and that happens, they have an IRA, and I'm the named beneficiary. Counsel me so that the listener can hear it. Counsel me, like, what would we do next, right? To figure out, what the options are.
Yeah. So, Stephen, I'd say very first thing we have to do is, before we even talk about the process, the forms we need to complete, let's figure out what options we have and what you are most comfortable with, what you're interested in pursuing, right? Whether that be a lump sum distribution, an inherited IRA for yourself, maybe you want to disclaim it. We would go into potentially some other options, were those on the table. But, I'd ask you, we'd look at the different options. I'd probably send them to you in an email or some form, right?
Sure.
Review these. Let's go over them. Let's find out what you're most comfortable with.
Got it. Collin, I have, I have a lot of stuff that is going on right now, as you can imagine, with the family, et cetera. I understand, we need to take care of this, but, I want to grow, that cash too. And, my goal is just to keep on reinvesting that money until, I'm 50 or 60 or whatever. And maybe I'll take some out. Maybe I'll, find a way to give it to my children as well.
Yeah. So really the longest that you're going to be able to maintain it within an IRA is 10 years. Now, obviously, at the end of that 10-year period, all of the money will still be going to you as the beneficiary, right? You can distribute all of that, continue to reinvest it, maybe not necessarily through an IRA, but all of this money will be yours. And I think if you are wanting to continue to reinvest it, the best option could be to set up an inherited IRA account, transfer those funds in there from the deceased account, and be able to reinvest it however you see fit.
Got it. So help me understand this inherited IRA. So we have entity one, which is that we'll call it source IRA, right? Where the parent had an example, and then you're talking about this inherited IRA as the target. Would like the cash that my RMDs would have to go into a bank account as part of distribution, and I take that and have to reinvest it into an inherited IRA, or could it just go directly to an inherited IRA?
So yeah, it can go directly into an inherited IRA. I mean, this is probably, again, one of those things where depending on the institution that you're moving it to, the process is going to be skewed a little bit.
Okay.
So we like to review, like a certified copy of the death certificate, something in writing that's validating that this transaction is possible, right? And aside from that, the IRA establishment process, and it isn't any different than any of our other accounts, other than you're selecting an inherited traditional or an inherited Roth IRA or whatever that is. But same process, just to set up the IRA, we like to review a certified copy of the death certificate, and then we'll assist you with actually getting the money and the assets moved over. And one thing that makes it more difficult with the assets is then you have to have all of that retitled as well. So it can be kind of a long and arduous process, admittedly, especially with investments, alternative investments in particular.
Yeah, paperwork's got to be clean, I'm sure. Is there anything we should know about this inherited IRA? Is it just functionally pretty much the exact same thing? Is it just we have to do these things for government tax purposes?
Yeah, essentially. I mean, understand your options. Certainly understand that it's something that you do need to keep up with, making sure you're updating, especially when any major life events happen, right? Divorce, marriage, anything like that.
Sure. Okay, I have a question here. Why in the world would someone want to disclaim or not accept the inherited IRA? I'm trying to think of, apart from bad blood and I don't know.
Yeah.
Like, that's the first question. I guess the follow on to that is, can someone just name someone else a beneficiary and they not know? I guess it's possible, right?
That is a perfect question. And the reason that outside of like you said, bad blood, or, I haven't talked to my dad in 30 years and he left me all this money, I don't want it, right? That happens. But outside of those scenarios, it's really, a spouse who doesn't need the money. Maybe it was a small IRA account. They've got the life insurance policy. They've got the other things. They want their kids to have the IRA, right? The issue with disclaiming for that purpose is you have a no say and who actually gets to inherit it. And people will go ahead with disclaiming their spouses or their parents' IRA in the hopes that it goes to the person that they want. But if there are no longer any beneficiaries listed, so I shouldn't necessarily say that. Let's say that there's a contingent beneficiary listed on the account, and that contingent beneficiary is the children. Then at that point, maybe the spouse disclaims, then it would pass to the contingents. But if there's so like a secondary beneficiary, right? But if there's no contingent plan, there's no contingent beneficiary, there's no one left for it to go to, it's going to pass to the estate. It's going to go, again, we're going to use that word probate. It's going to go through that probate process. Right. And at that point, it's up to the state how that's handled, right? You have no say in where the IRA is going.
Okay. So let's touch on that for a moment. I want to go back to something afterward, but since you mentioned the P word a second time, talk to me about what that is, why people don't really like probate that much.
Yeah. I think, both of us have already alluded to it a little bit, right? But it's basically the process of having your unclaimed assets or untitled assets divided to your beneficiaries or those that have outlived you. Right. And so things that are named in a will, things that you have in a trust, those kind of things are taken care of, right? Your IRAs that have a beneficiary listed. But sometimes it's the things where maybe if you don't have a will, or there were particular assets you acquired after your will was established that didn't get updated. Right. So it's those kind of things that will pass through probate. Probate essentially is this process that goes through the court, and the state or the court decides what's going to happen with the deceased's assets and investments and properties, whatever is there, Yeah. So not only does it take very long, there has to be, a case assigned. You have to determine who are eligible beneficiaries. You have to determine what assets are going to be put into probate. And it takes a while to do, research and findings on these assets. It can just take months, sometimes even years to actually go through probate. And even then, there's no guarantee that the outcome is going to be what you want it to.
Right. It's at the speed of the government based on your specific state and county and wherever you are. So for all my tech friends listening on this one of the things that I was thinking about for an analogy is I was learning about this for the first time was it's kind of like every computer and system has a default policy. And if you don't make a decision, you're going to hit that default policy, and that's the state and probate. And so if you, it's, not to take a left turn on this, but it's like, it's kind of like the way I was thinking about even, a prenup as an example, or a will, whatever, all these same things. Like set your own policy so that it's something that you want to happen versus letting the default policy to do it. Because whether or not you want it, the government will get involved.
That's right.
So anyway, thanks for going down that one. So that's so you can disclaim so that it goes to the next in line, right? So if the spouse is first, they're contingent, they can disclaim, and they will go to the children as an example. Got it. So that's why someone might want to disclaim because they wanted to go somewhere else. Mm-hmm. And then the other scenario might be they haven't talked to their mom, dad, whomever in a long time, and they're like, no, I don't want this money, and then it just goes to probate.
Yeah, it's incredibly rare that we see somebody disclaim, but if it happens, it's generally for one of those two reasons.
Okay, got you. So an option here was to take a lump sum on the money. Mm-hmm. Now, depends on the size of account. I do get that. But let's just say, I don't know, let's just say there's $100,000 in it as an example. If I take a lump sum, I'm getting taxed and all of that. Who's getting taxed?
So yes, if there are taxes to be had. And this is where, when we go back to the advantages of the Roth IRA,
right,
specifically when it comes to legacy and estate planning, if you've satisfied that, because one of those, even if you're not 59 and a half, one of those qualifications is death or disability, right? So if you've had that Roth IRA seasoned, it's been set up for 5 years, essentially. After your passing, technically your beneficiaries can take that Roth IRA, take a lump sum distribution without any taxation at all. So no taxes to your estate, no taxes to your beneficiary either.
Got it. So that's with the Roth, which makes enough.
So traditional, different story, where it would apply to basically the beneficiaries' taxes. So their tax bracket, it's their taxes to pay, all of that.
25.x% based on whatever, if they're doing it on their own and they don't have another way to bring it down, kind of thing. Yeah. Okay, that's fun. So it's I'm not going to make that analogy. I was going to say it's like winning the lottery, except not a good scenario. Got it. Okay, so there's the taxes to be considered. Cool. Is there anything else you would mention there? So there's lump sum, there's, possibility to disclaim or take it into an inherited IRA, or like 3, right?
Yeah, I think that's pretty thorough. One thing I will say is trusts. A lot of people like to name their trust as the beneficiary, so that basically they can make the trust rules however they want. And that, the trust can own their other assets as well. And then eventually the IRA assets, once they pass and everything, moves over there or is inherited by the trust. And then at that point, the trust or the trustee dictates what happens to them. So that happens frequently. But I will say, for most people, because of the advantage that a spouse gets as the beneficiary, it always makes the most sense to name them as your primary. And then, I guess I shouldn't speak in absolutes. almost always makes the most sense to name your spouse as the primary beneficiary and kids or a trust or something like that as contingent.
Same laws apply, or not laws, same rules apply if it goes to a trust, like a 10-year RMD?
Yes, exactly.
Okay, got it. And that...
Sometimes, and this is where I was 10 years at most. Sometimes it can be shorter than that, depending on if, like, how the trust is set up. Was it a living trust? Was it, irrevocable upon death? Was it revocable past death? Right? Depending on how you and your estate attorney set that up could change what rules are essentially allowing the trust to inherit everything. So whether it's a qualified or disqualified entity is essentially what we're talking about.
Got it. There's definitely some options and some terminology and concept understanding there. So let's sort of button up this topic then on this. So, you're in this case, you're a named beneficiary. You have a couple options. You can disclaim it and not want it, and it will go to beneficiary or whoever else, quote unquote, not your problem. You can take a lump sum, or you can start, if it's in this scenario, you can start getting distributions and you can do something with that cash as well, potentially another IRA as well. Is that about right? Cool. So you mentioned estate planning here a bit too. Unfortunately, this is what you were doing previously to being their request. So we're in good hands on this. So let's think about this from the perspective now. I'm 34 years old, about to be 35. I know you can't tell. Just saying, good genes. But I'm thinking about all these different entities and things I can do for my kids and other beneficiaries as well, right? Mm-hmm. And so, most of us will have some kind of IRA. Not everyone might have an SDIRA yet. Go back and listen to episode 1. It's how do we think about this? Like, what are the things, the questions we should ask on estate planning, on setting up, these IRAs to make it optimal for passing it down to our beneficiary?
Yeah, I mean, I think it's, kind of some of the things that we've already talked about, right? First of all, who do you want to inherit your accounts? You maybe want it first to go to your spouse, then split between your kids. Maybe there's a trust involved. So those are important things, right? And actually making sure, regardless of where you set up an IRA, whoever it's with, that you do list beneficiaries on there, right? Even if it's always something you can update later on. But I would always encourage people to set it up with beneficiaries there listed.
Got it.
And then, speak with, like, if you do have estate plans already in the works and you're trying to figure out how all of this fits in on top of that, because, things can vary from state to state, talk to your attorney, talk to whoever, the estate planner that helped you set up everything. I think that they can, give you a really great idea of kind of how your IRAs fit into the picture as well, and where it makes the most sense for those to be inherited, whether it should go straight to the kids or whether it should go maybe first to a trust.
Got it. Any, again, not legal advice, all things just for our information, sharing your experiences, et cetera, et cetera. Talk to me about, since you have some experience there, when in someone's life, it might be a good idea to set up, some estate planning. I haven't done any estate planning yet. So I'm trying to think, like, do I do it now? Do I do it in 10 years?
Yeah, that's a really, really great question as well. I would say once you have dependents, whether that be, and maybe not in the tax sense, so maybe not just children, but a spouse. I think it would be, a wise decision to have some sort of estate plan in place. Whether that be, a very basic will, just something that's there. And any life-changing, especially traumatic events is always a really great time to review and update that information. So when you have kids, when you get divorced, when your kids get married, when your parents die. It's a great time to review all that stuff. I mean, there are a lot of different these life events that certainly could change, who's going to be listed in that will, what assets are in the will, what else am I missing, right? Those are really great opportunities to kind of review that stuff, and something that can be missed oftentimes.
Yeah. So not only those big events, annual reviews, type of check-in, good best practice as well.
Absolutely.
Okay. Yeah. Okay. So it's good signals, definitely dependence, and then, additions, removals to the edits to the family tree.
Exactly.
Sorry, not to be clinical on this. I was just thinking systems. All right. This is for tech professionals, Collin. All right.
That's right.
Wait for Gen AI, dude. I'm just saying,
Yep.
Yeah. I mean, that side note, that'd be kind of interesting. We won't go down that rabbit hole. Yeah, AI in our estate planning. So,
Wiggle Zoom and all that stuff.
Yeah. There's never mind. All right, good stuff. Okay, cool. So setting those up. Do you, in the case of Quest, with you as an example, would you talk to, what does the communication look like? What should it look like? What are your thoughts on, if someone goes to set up an IRA with you, do you guys talk to an estate attorney? If someone wants to make sure that's part of it, do you even have to talk to them? You just give them paperwork? What does that look like?
Yeah, I mean, we don't necessarily. We kind of take a more conservative stance on that stuff, not trying to give any sort of legal advice, Anybody that does have questions, I will always encourage them to talk to an estate attorney or a financial planner, somebody who can give them advice and give them a more solid answer. A lot of times people don't have a ton of questions about that, but it's also something that they're not as concerned about at that point in time, right? If they're setting up an IRA, certainly they're probably not too worried about what's going to happen after life. So they'll name the wife, they'll name the kids, they'll name their trust if they may want to. And some people do that. Some people have estate plans set up and it's all very detailed and they want to name the trust first, and that makes the most sense for them. And great. We don't generally run anything by like an estate attorney, but I would always encourage somebody to.
Okay, got you. So basically, is the people who would come to you and set things up, they would have the documentation they need to go directly, just talk to the estate attorneys directly.
Yeah, and that happens. And some people already have trust established. They want everything to pass there, and we'll hold copies of that stuff if we need to. So we've got trustee information and whatever else is there, and then they can always update that with us as well.
Got you. So you've talked about trust a couple times now. I mean, we talked about the beneficiaries first topic, the second one, things to get in order, considerations when, I might be the person setting up, an account so that my spouse or children will get it. This next section is what we were talking about is the cold hearth truth segment of asset protection. Yeah. And so, again, you mentioned trust a couple times. So just, loosely define what is exactly a trust here so that we can wrap our heads around that.
Yeah. To clarify a little bit, a trust is a type of entity oftentimes used for asset protection in a lot of different ways. I mean, it's a very common estate planning tool. It's used very often in the real estate world. You have estate trusts, from revocable to irrevocable to living trusts to springing trusts. You have land trusts on the real estate side. They are a very multifaceted entity that we see in a lot of different ways. So kind of similar to like I guess if you want to think about it in respects to an LLC, right? You have the trust or the LLC, which is the entity. You have the trustee or the manager, which operates that entity. So similar aspects. Trust can hold all of those assets. They're really used as an asset protection piece a lot more than other entities would be used: corporations, partnerships, LLCs, things like
I think one of the things that I've always heard about them is that they're really good from a privacy perspective, right? So assets can be held in trust, and you when things are, I guess, filed or not filed, you can have that trustee who is on public record, but beneficiaries aren't necessarily on public record.
Yeah, and even with I forget the Corporate Transparency Act. Not sure if you've heard a ton about that, but especially with LLCs, as of the first of this year, there's a whole lot more reporting that they have to do. Reporting managers, members. If any of those people are entities, then those entities have to report their managers and members, and all of that stuff is a lot more detailed when it comes to what you're showing the IRS, especially, and even when those things are established in annual reports and whatnot. So a lot of those LLCs have had to go through kind of recently a period of exposing a lot of that stuff.
Right. Who owns what, and are they managers and shareholders?
Yeah, so the government is certainly cracking down on that. But and to your point, that's related specifically to LLCs, so kind of an advantage trust there.
Yeah, the trust will not. You don't have to show who the beneficiaries are. Got you. Awesome. So again, this section is just touching on some of the parts here of, let's say that, well, you set the stage. How does this look like if, I have an IRA and I get sued, right? This is one of the scenarios that we were going to talk about, correct? What does it look like? How are IRAs treated if there's some kind of lawsuit?
Yeah, so the nice thing, and this is, I would say comparatively to like an LLC, it's for the most part going to, that lawsuit would be to that entity. So the assets within the IRA could be subject to that lawsuit. Right. If you have, say you have a rental property, you have a tenant in there, they fall down the stairs, or have a friend over that falls down the stairs, right? That's a pretty common example. They sue you, or rather your IRA. So that IRA and its assets would be subject to lawsuit, right? Or to creditors.
Right.
So one thing that some people like to do is set up separate IRAs for each of their properties.
Got it.
That's something we see.
Got it. So the use case is actually, or the scenario actually is, I'd have an IRA and I bought a property, or I invested, bought a property, and put the IRA on property title, right? In that case, the tenant has a friend who gets hurt, sues, and wins, and then creditors would come and say, hey, the IRA owns these types of assets, and trying to access that rental property. So like the IRA itself could act as a barrier like another entity would.
Yeah, exactly. To like say assets in other IRAs to personal assets, it kind of gives you a protection against some of that. So,
got it. Okay, that's pretty much the scenario. Would there be any cases where creditors might be able to go to other IRAs?
So yes, sometimes. Now, this is what we call piercing the veil. And this is when, I wouldn't relate this as much to like a real estate scenario as I would potentially like a let's see, like something very, very negligent.
Okay.
If the IRS or I guess rather the court decides that there was negligence involved and certain other things, right? I'm not an attorney, so I'm not super privy to this, but basically there are instances in which if you are found the guiltiest of all guilty, that the lawsuit can pierce the veil and come after potentially other assets,
Okay.
as could happen with really about any entity. So that's not entirely different, but yes, it is possible.
Okay, got it. Yeah, I don't. So negligence would be like. I mean, is that really? Have you seen that really happen? I mean, there aren't too many moving parts with the IRA, right? Like, I mean, there's a reason why we have there's a custodian request to make sure things are done well. Like what cases? I'm trying to think of what cases might there be where there's been some kind of negligence. Would it be like on more the property level in this scenario?
Yeah, in terms of a property level, like I would say if you had, like if there was a breach of contract between, tenants and the landlord or the IRA, so to speak, right? They had been asking for months and months and months and months and months. That's something
Okay,
fixed.
got it.
A scenario like that is where there could be a piercing of the veil.
Got it. So negligence around managing the asset that the IRA invested in and how that might affect just total operation of.
Yeah.
Okay.
Yeah,
got
absolutely.
it. And that could be, I know we're talking rental property, but that could be anything the IRA is invested in where there might be a lawsuit, right?
Yes.
Got it. So, if it was invested in multifamily, invested in anything else.
Right.
Okay.
Yeah, could apply to any asset.
Okay. What else is there to mention on this topic that comes to mind?
I would say those are going to be some of the biggest things. Yeah, we really, when it comes to asset protection, I mean, we compare it to, any other kind, like a trust, right? I mean, an IRA technically is a type of trust. It can be set up with its own social security or tax ID number. It has its own name, its own level of asset protection, right? We already kind of talked about that barrier, that separation between you and entity. I'd say those are really the biggest things.
Okay, got you. So we covered a good amount there. I think, just knowing what the options are on, inheriting an account, lump sum, am I or not, or are you or not in the position to start taking some of those RMDs? Are you, disclaiming, which is always an interesting word. And then just, things need to do to put together, making sure my own account hygiene as well. I'm thinking about, is it a good time as well to start setting up an estate when I have my own dependents? Just being clear about like what that looks like from, using investing in with LLCs or investing with your SDR, your IRA, and what that looks like. What is the next logical step for conversations that you might have with the clients that are, after a topic like this, or for them to think about, is there anything else that a client might need to know around, really making sure they have a great plan for their IRA if they know all the things in like episode 1 that we covered with all the basics, episode 2 of all the different entities, and then making sure that they know how to pass on to their beneficiaries. Is there anything else you might recommend to talk about?
Yeah, I mean, in terms of the IRAs, there's really not. We've, like I said, when we started out, we've gone pretty deep into detail on a lot of this stuff. And really what's left to do in terms of the self-directed investments is really your knowledge and expertise when it comes to investments, your due diligence, right? And that's kind of, obviously with the multifamily stuff where you really come into play, and I'm sure other episodes on your podcast and whatnot, have information privy to that too.
Yeah, absolutely. Well, I know that like I said, there's a lot of things that options and tick boxes and dependencies on what to go. I really want to urge people to reach out to you for questions. Tell everyone again, Collin, where to reach you, and of course, we'll make sure that those go in the show notes too.
Yeah, so you can look us up, questtrustcompany.com, QUESTTRUST, questtrustcompany.com. My email is Collin, COLLIN .Taylor, TAYLOR @questtrust.com.
Yeah.
And you can also call us. Our general line is 281-492-3434. Happy to have a conversation. Happy to set up some time to speak. If you want to call in, ask to speak to me. I'm the only Collin that works at Quest. So call in and ask for Collin. That's my slogan.
Love it. Call in, ask for Collin. Perfect. Well, thank you, man. Do appreciate it. And maybe I'll have another episode in the future.
Maybe so. Hey, maybe we'll have some Secure Act 3.0 updates for you, Stephen.
Yep. Thanks,
right.
sir.
Thanks for joining us on another episode of Path to Passive. We love connecting with our listeners and those on the path to architecting their wealth and improving their lives. Feel free to let us know what topics you'd like to see in the future episodes. Get in touch with us through email or Instagram. See you next week for a new episode.